Happy birthday, Tamara.
Happy birthday,
They have to prove that the mischief was not committed, that the intimidation was not committed, and that the resisting police was not committed. That's an essential part of counseling.
Every counseling under that section is counseling an indictable offense that has not been committed. Okay. That's the labeling of the charge or the offense in the criminal code.
Robert Krajcik here in Ottawa, Ontario for Rebel News at the conclusion of the 10th day of the trial of Tamara Lich and Chris Barber, both of whom are being charged with crimes associated with their organizational efforts with the Freedom Convoy in 2022. Broadly, a demonstration of protest against what I call the COVID-19 enterprise, these measures and decrees and edicts issued by government ostensibly for the purposes of public health. Before we continue, please visit tamaratrial.com to stay up to date with our ongoing coverage of the Tamara Lich and Chris Barber trial, and please consider donating to us so that we can continue providing these reports to you out there in our beloved audience. The day's proceedings were primarily dedicated towards dealings with the latest witness for the prosecution, a city official here in Ottawa named Kim Ayotte. Ayotte's role was and remains a sort of directorship, a managerial position over the emergency services in the city and also bylaw services. So he's in charge of the fire department, police department, also these sort of bylaw services that issue tickets for smaller infractions like parking violations. And the major takeaway of his testimony today was that he came essentially without notes or logs to refresh his memory in the event that he may be asked a question in cross-examination or by the prosecution where he may not specifically recall what had happened. Lawrence Greenspan, the defense attorney for Tamara Lich, repeatedly remarked on his lack of notes and stated to the judge when Ayotte was excused that he finds it almost impossible to believe that Ayotte will be able to specifically, correctly, accurately respond to questions and queries regarding the evidence that he might provide, given that he did not have notes with him regarding his role as a city official.
As I say, the notes are important to assist witnesses when they're giving their testimony under oath, and that's why I anticipate that Mr. Ayotte, like any of the other witnesses who have taken notes, will testify with those notes as an aid.
Another major takeaway from the day's events was a moment in which Lawrence Greenspan, defense attorney for Tamara Lich, explained to the court and to the judge particular features of one charge that's levied against both Tamara Lich and Chris Barber. This is the charge of counseling others to commit mischief. In order for the prosecution to secure a conviction on this charge for either defendant, the prosecution must prove that the mischief that was allegedly counseled by Barber and Lich for others to commit was not committed. I need to repeat that because it may be strange. It may be difficult to comprehend. Again, the prosecution must prove that the mischief allegedly advised by Lich and Barber for others to commit was not committed in order for them to secure a charge on this conviction.
So the offense of counseling within the criminal code is worded in that way. So it's counseling an offense that has not yet occurred. That's the wording of the criminal code. It gets more complicated here because the Crown is alleging offenses not yet committed and offenses also committed, and that's why there's several charges.
All three counseling offenses require the same thing. They have to prove that the mischief was not committed, that the intimidation was not committed, and that the resisting police was not committed. That's an essential part of counseling. It's what we call a condition precedent to counseling, is you have to prove that it wasn't committed, because if it was committed, then they go after you as a party. So you can't have counseling something not committed on the one hand and on the same information, the actual charge.
The final major takeaway of the day's events is essentially a consensus that existed between the judge and the two defense attorneys regarding the questionable relevance of the testimony provided by Kim Ayotte, given his role as a city official and given the nature of his testimony. Specifically, Kim Ayotte's role as a manager of city services created a sense of testimony or understanding on his part that was primarily composed of second-hand accounts. So his understanding of events during the Freedom Convoy, his testimony as to what occurred, was primarily predicated on what he had been told by his subordinates. He stated on the stand that he has 2,500-ish subordinates, and also information he received from his counterpart colleagues. So Greenspan, Magus, and the judge repeatedly questioned whether or not he had sufficient first-hand experience, first-hand observations of the statements he was proceeding to make.
I can't comment on the Crown's aspect of things or how they're putting their case together, but witnesses in and out is something we're used to with lawyers in courts, objections, and usually you get the witness out so that they're not tainted by the argument of the lawyer. They don't understand what it is that it's being objected to, so that the witness can be as neutral as possible. So that's not unusual at all.
But something might have looked unusual, the preparedness level of the last witness. The whole issue with the notes, the camera, I don't need my notes, I'll refer to my notes. Is that unusual, or you seem to have reacted to that too?
I can't comment on that because that's actually a live issue. The witness still on the stand, and I would not be able to do that.
Generally speaking, though, we've gotten through 3 witnesses so far. The Crown's estimates for how long this is going to take appear to be way off. And so I'm wondering if you can give some kind of context about how far off we are.
Well, I made the comments on in court. I can't comment more. These comments will have to be made to Her Honor at that point if it becomes an issue. Right now, we're putting the comments on the record so that the court is aware of the concerns that we have, but we can't comment more.
Can I ask you a question about one of the claims Greenspan made in court? He remarked on the obligation on the prosecution to prove that mischief was not committed with respect to the charge against both Lich and Barber that they counseled others to commit mischief. Dear Rebel News audience, if you appreciate and value the reporting that we're delivering out here in the field, please remember that we cannot do this for free. We have operational costs. We need your support to continue delivering these reports. Please visit tamaratrial.com and contribute to our operations.